made it likely that prisoner-to-staff violence could occur. Yet nobody ever bothered to reel them in, not their co-workers, nor the people who supposedly were there to supervise them. Then there were guards who just wanted to do their 8 hours and go home, and they didn't care what happened while they were there. While that might sound like an ideal attitude that you'd want a guard to have if you had to be incarcerated, it didn't actually work out that way in real life, because it would not be unusual for them to literally look the other way and walk in the opposite direction when violence was occurring, so as to be able to avoid breaking things up and filing paperwork afterwards. There was a system of maintaining order in the prison known as keep lock, which involved a variety of sanctions being imposed on the prisoners if they were found guilty of having broken a prison rule. Some of those conditions included, but were not limited to, being kept in the cell 23 hours a day out of the 24. They would send you less food. Sometimes the food they would send you would be 3 or 4 days old. Their idea of complying with the court-mandated 1 hour a day recreation consisted of putting the prisoners in a small caged area with maybe a pull-up bar in it, if you were lucky. You would be able to take 2 showers one week and 3 the next, rather than being able to shower daily as the rest of the population. You would not be able to use the phone while you were on such status. In the facility in which I spent 13 and a half of the 16 years, Elmira, it was particularly violent there. There were 3 or 4 stabbings or cuttings every day, no shortage of violence that didn't involve weapons, and there was plenty of gang activity. Taken together, there was a general atmosphere of violence and adrenaline that permeated the air. There were several times in the course of my incarceration that I was assaulted, and one time in which I nearly lost my life. In addition to dealing with the physicality of that, I was subjected to those sanctions that I just explained, because in prison, if you were defending yourself, then you were fighting. While I was in prison, I tried to minimize the loss that I was experiencing. I obtained a GED, and I got an associate's degree, and I completed a year of schooling towards a bachelor's. But then even this silver lining was taken from me, because in 1995 in New York, George Pataki became governor, and he decided it would be a good idea to cut the funding of college education for prisoners. He did that on the state level, and Senator Helms did it on the federal level. It was like a chain reaction throughout the country, where the colleges really left the prisons. When that happened, I looked to the vocational trades to try to do something positive with my time. But although I amassed many certificates, it looks much better on paper than what it actually is in reality, because the material was obsolete 5 years prior to my having stepped foot into the shops. I remember the pay grades that they gave the prisoners there for their assignments, whether that was educational, vocational, or in one way or another related to the running of the prison. I remember they paid 16, 22, 25, 32 cents an hour. There were a limited number of positions that paid 38 cents an hour, and there were 4 precious 42-cent an hour positions. Out of that money, the prisoners were expected to purchase items that were not given to them by the state, such as shampoo, deodorant, postage, pens, paper. And if miraculously there was somehow something left over after that, that would be important, because there were some limited food items which could be purchased at the commissary. Because in general, the food in the prison was not very good. Sometimes the food would be burned, at other times it wouldn't be fully cooked, while at still others there was problems in terms of the portion amount, while other items found their way onto the menu 4 or 5 times a week. In 1996, the prison told me that they received information from the hospital that my grandmother was extremely sick and in the hospital, and she was not expected to survive. And so I had a choice. Did I want to wait until she passed away and then go to the funeral service, or did I instead want to see her while she was alive, yet in a coma? Now at that point I had been incarcerated for 5-6 years already. I had already lost a few appeals, and I was serving a life sentence. And I knew that there were many members of my extended family that had never come to see me in the prison, and who in fact would never come to see me while I was incarcerated. So waiting until my grandmother passed and going to the funeral service represented the last clear opportunity I would have to see those members. As you might imagine, it was a very difficult position to be in. I mean, would it really kill them to allow me to go to both? Yet that wasn't how the system worked, and I had to make a choice. In the end, I decided to see her while she was alive, yet in a coma. We left Elmira early in the morning prior to the population being served breakfast. The guards were given funds with which to purchase food items for themselves and for me. But although they got something to eat, I was merely provided with a cup of coffee. Because of the fact that I've always suffered from motion sickness, there were several times, and I hadn't been given anything to eat, there were several times that they had to stop the car and pull over because I was on the verge of vomiting. Yet, because nothing was in, nothing came out. I guess I was lucky in that sense because I had on handcuffs and I had a chain around my waist, and even though there were two guards and they both had sidearms and a shotgun, and surely I posed no threat to them in that position, they were unwilling to loosen the handcuffs even a little bit. So had I gotten any vomit on my clothes or on my face, I wouldn't have been able to wipe it off. When we arrived in Peekskill, 3.5 to 4.5 hours away, they parked the car as far away from the hospital doors as they possibly could, so as to be able to parade me through the parking lot. Again, keeping in mind that I had on handcuffs and I had a chain around my waist and I had my legs fastened together. I remember there was a nurse attendant who was on duty who did a double take at the sight of me. And there was a child who was probably around 5 or 6 years old, and she was running around playing. When the mother got a sight of me, she grabbed the child and brought her close to her as if I was some kind of violent animal that was going to commit a spontaneous act of violence right there on the spot. It was definitely a humiliating situation. When it was time to go, the guards came in the room and informed me that my hour was up, but I saw on the clock that in fact it had only been 45 minutes. But they insisted it had been an hour, and they forced me to leave. Again, parading me through the hospital corridors and the parking lot. This time on the way back, I was allowed to have something to eat. But by this time, 45 minutes later, the parking spot which the vehicle had been sitting at, it lent itself to sunlight kind of beaming through the windshield, and so by now the vehicle had become quite hot. Although the guards turned on the air conditioning in the car, none of it reached me because there was plexiglass fully separating the front of the vehicle from the back, and they were unwilling to lower the windows even a fraction of an inch. All told, I suffered for about 7 to 8 hours in order to visit with my grandmother for less than 1 hour. Towards the end of my sentence minimum, the prison authorities told me that if I wanted to have any shot at all of making parole, which was already a slimmer than slim possibility as it was, that I would have to take and complete the sex offender training program. The problem with taking that program, however, was that there was an explicit guilt admission requirement. I would have to admit guilt, not simply to the instructor, but also to the other prisoners in the class with me. They would not accept it if I simply said that I was guilty, but they wanted me to give details. A verbal rendition would not suffice. It would have to be done in writing. Failure on my part or anyone else's part to comply with any of those aspects would have resulted in the immediate removal from that program, and I would have been deemed to have refused to complete it. So once again, I was in a very difficult position, and certainly I was looking at parole as a potential means of regaining my freedom, and clearly I wanted to do that before anyone else in my family passed away. After a lot of soul searching, I decided that I would not take the program. I couldn't bring myself to give details about a crime that I did not commit. When I went to the parole board hearing, I knew that the parole board was in the habit of rubber stamp denying parole applications, even from applicants who could demonstrate that they had turned their lives around and would, if released, not pose a threat to society and hence would not get arrested. So in order to try to protect myself from having that happen to me, I kept raising the issue of my innocence and citing the DNA. But they were unwilling to consider even the mere possibility that I was innocent. Towards the end of the interview, one of the commissioners asked me a question about an aggression replacement training program that I had taken, and I was able to give them the answer, demonstrating that I had learned the material in the class. That's when another commissioner piped up and said, "Well, that's good, Mr. Deskovic, because you're going to need those skills once you return back to society. Good luck." Now, the procedure is that they don't inform you of their decision on the spot. They instead send it to you via institutional mail 3 days later. Considering how the interview ended, I actually walked around the prison for the next 3 days thinking that I had somehow defied the odds and that I would be going home. When I got the decision in the mail, it noted that I had a good disciplinary record, that I had an excellent educational record, that I had a few letters of support, that I even had a prison employee recommending that I be released on parole. Yet, nonetheless, I was convicted of a brutal and senseless crime, and to release me would be to deprecate its seriousness. They turned me down and ordered me to reappear in front of them 2 years later. Now, considering I knew many prisoners there who were working on years 25 and 30 off of a 15 to life sentence in which they would go to the parole board, get turned down, reappear, get turned down again, and kind of have that cycle continue in perpetuity. It was at that moment that I thought that I was going to die in prison. I would like to share with you how it was that I came to be cleared. While all this was happening, and a lot more than I'm skipping over just for the sake of time, I was simultaneously appealing my case throughout the court system. I went to the appellate division, the first court one must go to. My primary issues on appeal were my innocence as demonstrated by the DNA and that my Fifth Amendment rights had been violated. The court found nothing wrong with the way I had been questioned, and furthermore, they ruled that there was overwhelming evidence of guilt, which made no sense because the forensics were in my behalf. There was no physical evidence. They ruled against me 5-0. My lawyer moved to re-argue the case, arguing that the decision was running contrary to the facts and to the law. But the re-argument motion was denied. I then went to the Court of Appeals, New York State's highest court. The procedure is that you have to obtain permission for them to appeal before they will agree to let you argue the issues. The Court of Appeals told me that there was no merit in law to justify reviewing my case, and therefore they were declining to review it. I then looked to the federal court for relief. I filed what's known as a petition for writ of habeas corpus, which is when a state prisoner is arguing that his or her conviction is running against the United States Constitution. Again, my primary issues in that petition were my innocence and also my Fifth Amendment rights. Now, at that time, there was confusion in the federal court system because 1 year prior, Congress had passed and the President had signed into law the Anti-Terrorism and Effective Death Penalty Act, which in relevant parts stated that all state prisoners would have 1 year to file in federal court after being denied by their state's highest court. The confusion with this new ruling was centered around how would this apply to cases that were already in the system, and different jurisdictions were answering the question in different ways. So my attorney contacted the court clerk and asked for clarification. Would it be enough that my petition be postmarked on the due date, or did it have to be physically filed and in the building on the due date? The court clerk told my attorney that it would be enough if it simply be postmarked. Well, unfortunately, that turned out to be inaccurate, and as a result of that, my petition arrived 4 days too late. Former Westchester County District Attorney Janine Pirro and New York State Attorney General candidate, her office took the position that those 4 days were somehow prejudicial to the people, and therefore the court should simply rule that I was late without even looking at my innocence argument supported by the DNA.